Hello everybody and welcome back to AQA A-Level Politics. In this video what we're going to do is move on to the next major topic, topic number 4, and this topic concerns itself with the UK judiciary. We'll take an introduction to the judiciary in this video before talking about the concepts of judicial independence and neutrality in the next video, appointments to the judiciary, the powers of the judiciary, and some of the political relationships that are had between the judiciary and the other branches of government within the UK's political system. Like I mentioned, we're going to be taking an introduction to the judicial system in this video. We will delineate between the different types of legal system that exist, so the distinction, for example, between the civil law and the criminal law. We'll also talk about the distinction between the idea of having a UK judicial system, but also talking about law as delineated between Scotland, Northern Ireland, and England and Wales. And then we will finally finish by talking about the process and the role of judges within the UK's judicial system. So what do we mean when we talk about this idea of something known as the judiciary? What is the judiciary, fundamentally? Well, the term judiciary refers to the general collective of judges. Now, it means that every single judge, whether we are talking about judges that represent what are known as summary cases in magistrates' courts, all the way up to the most important cases in the Supreme Court, are all part of this collective institution that we refer to as the judiciary. Now, it should be noted that there is a distinction between the courts in England and Wales and the courts of the devolved legal systems. And it is not devolution that creates this distinction, however. It is historical precedent which creates this distinction. So when we had, should I say, the Acts of Union in the 1700s between England and Wales, and on the one hand, and Scotland on the other hand, there was the decision to for Scotland to retain its legal system. And ever since then, the domestic law of these two different countries are distinct. There is a difference between Scots law and there is a difference between law in England and Wales. When we talk about constitutional issues and issues that are of paramount importance to international law and also to the law of the European Union, for example, we are going to be talking about them as a collective UK constitutional law, okay? But when we think about the domestic legal principles, so things like the criminal law or contracts, these are things that are divided between the different legal systems. There is a Scots law, and then there is a law of England and Wales. The reason why England and Wales have the same legal system is because in the 1200s there was a unification of the legal systems of England and Wales, and that common law sort of just developed over hundreds and hundreds of years collectively. This means that it is incorrect for you to say and to refer to, quote, UK criminal law or UK contract law. That does not exist. There is no such thing. It is the law of England and Wales, or it is Scots law. That is the distinction that we have to make. Northern Ireland and Scotland have different legal systems to those of England and Wales. There is a really good example of where this has been illustrated. Take the landmark Supreme Court case of Cherry versus Boris Johnson, or the second Miller case. That's not the full citation that I've listed here. But fundamentally, in this case, the High Court of England and Wales had a different ruling to that of the High Court in Scotland, and the High Court in England and Wales disagreed with also the Supreme Court of the United Kingdom. So what has happened in this case of course refers to the attempted prorogation of Parliament and the question firstly of whether or not it was lawful, the question firstly of whether or not it was a justiciable question, i.e. a question that a judiciary can actually answer, and then yes or no onto that, whether or not it was therefore lawful. This was a question that had two different answers. The High Court in England and Wales ruled that it was not a justiciable question, that the judiciary couldn't touch that question. It was not a concern for the judiciary. It was a fundamentally political question. The High Court in Scotland disagreed and said that it was actually a justiciable question, and it was therefore something that the courts could actually rule upon. They both get appealed to the Supreme Court, and the court cases essentially merge together into what is known as the Miller case number 2, and the Supreme Court sides with that of the High Court in Scotland and says, in fact, yes, not only is it justiciable, but number 2, it was also unlawful. It was not lawful, and this was a unanimous decision back in 2019 that we will get to in future lessons, I'm sure. But this just illustrates that there is a distinction between the legal system in England and Wales on the one hand and the legal system in, for example, Scotland on the other. There is also a delineation that we have to think about very briefly between the criminal law and something known as the civil law. The criminal law refers to the legal regulation of crimes. A crime is an act or an omission, something, or a failure to act, essentially, that's what an omission is, which essentially is punishable against that individual by the state. The state brings cases against people who have been alleged to have committed crimes. Now, this is representative as the Crown Prosecution Service, the CPS. The state is represented by the Crown, and that's why when we look at criminal law cases, you see that the case is R versus whoever. Okay, R referring to Regina, or Rex, which refers to, of course, the monarchy, the Crown. And so the criminal law deals with crimes by individuals or groups against the state. In such cases, normally they will lead to criminal sanction. This includes punishments or imprisonments, etc., etc., etc. The civil law is very different, because what the civil law is concerned with is the interrelationship between different groups and different individuals. So it's not the state that gets involved in the civil law, it is other people. It's when you sue somebody else, for example. So, for example, there is contract, which is a civil law question, the law of tort, which is a civil law question, even the law of trusts, which are civil law questions for the most part. Contracts, as you know, relates to, just colloquially, a contractual relationship, an agreement between two parties. And if one of them breaches that contract, then the other person can sue. And the legal system that is relied upon in that state is that of a civil law jurisdiction. The law of torts, a tort is just a wrong that is committed by an individual for which there is compensation. So things like negligence is a tort, or defamation. You don't have to know any of this for politics A-level students. If you're doing A-level law, you definitely do, but this is just a general illustration of what the difference between the criminal law and the civil law is. Trusts, again, you really don't even need to know for A-level law. If you ever go to university to study law, you'll learn about trusts there. But these are civil law questions, and these are civil law matters, okay? And that's the distinction between the two. We are talking on the one hand about the relationship between the person and the state, and then on the other hand we're talking about the relationship between the person and another person, the interrelationship between individuals. Finally then, what is the role of judges? What do judges do? Well, at all levels, whether or not we're talking about summary judgments in magistrates' courts, or we're talking all the way up to the High Court or the Court of Appeal and the Supreme Court, judges at all levels are involved in ensuring that justice is done, ensuring something known as justice. At the lower levels, judges will preside over trials. So in civil and mostly in criminal cases, you will see that a judge is a trial judge, somebody who presides over trials. Now, in criminal cases at trial level, the judge has a very specific burden, has a very specific responsibility. They have what is known as the legal responsibility, or the legal burden over the trial. And then this is divided between the judge and the jury have what is known as the evidential burden. Okay, the jury is the fact finder of a particular trial, whereas the judge talks about or rules upon questions and matters of law. So the judge will direct the jury on questions of law and matters of law, and it is the jury that will make decisions as to the facts of a particular circumstance. So there is a legal burden, which is a judge burden, and then there's the evidential burden, which is that of the jury. At a higher court level, judges will hear more serious cases, and they will hear cases that are on appeal from lower courts. And the Court of Appeal, for example, and the Supreme Court are often and almost entirely adjudicating over matters of legal interpretation, over matters of law, not matters of fact. Okay? So a court of appeal and the final court of appeal, which is the Supreme Court, is generally concerned with the clarification of the meaning of law. The Supreme Court will hear appeals from lower courts, but will only deal with matters of law on a national level.